The door opened and the room rose. That is how it always works in that courtroom. That is how it has always worked. The moment the bailiff's voice fills the air and those chamber doors swing wide, something ancient and instinctive takes over every person in that room, something that has nothing to do with television cameras or production schedules or who is suing whom over what. Every body in that studio rises. It is not a thought. It is not a decision. It is the involuntary physical language of an entire room recognizing that authority has entered, and that authority deserves acknowledgement. Defendants rise. Plaintiffs rise. Audience members who drove 2 hours to be here and have been waiting in a holding area since 6 in the morning rise. Camera operators rise. Production assistants who have filmed hundreds of these episodes and have seen everything this courtroom has ever produced rise. Every single person in that room, without hesitation, without negotiation, without exception, rises. Every person except one. She was sitting at the defendant's table in a navy blazer that had been dry cleaned specifically for this occasion. Her pearl earrings caught the studio light. Her folder of documents was arranged in front of her with the neat precision of someone who had spent the previous evening organizing her case with the confidence of a woman who had already decided how this day was going to end. Her arms were folded across her chest. Her chin was lifted at an angle that anyone who has ever encountered this particular brand of suburban authority would recognize immediately. Her eyes were fixed on the far wall, not on the door, not on the judge, not on the bailiff whose voice was still filling the room with the announcement that should have brought her to her feet. She was looking at the far wall the way you look at something when you have made a deliberate choice not to look at something else. Deliberately. Pointedly. With the specific energy of someone making a statement through stillness. Her name was Karen Belfield. She was 44 years old. She managed rental properties in a quiet suburban pocket of California where she was known, depending on who you asked, as either a thorough professional or the kind of neighbor who makes people consider moving to a different state. She had come to this courtroom that morning to sue her former neighbor, Linda Marsh, a 68-year-old retired schoolteacher who had spent 31 years teaching 4th grade and another 6 years living next door to Karen Belfield, which by most accounts was the harder of the two experiences. Karen was seeking $4,200 in damages over a disputed boundary fence and a ceramic garden ornament she claimed had been damaged during construction work Linda had commissioned. She had driven to this studio absolutely certain she was going to win. She had her documents. She had her property survey. She had rehearsed what she was going to say. She was prepared for everything this courtroom was going to ask of her. She was not prepared for what happened next. Because at the moment every other person in that room rose to their feet, Karen Belfield stayed in her chair. And Judge Judy Scheindlin, who had walked through that chamber door with the measured pace of someone who has done this more than 10,000 times and has never once needed to announce her own importance, stopped walking. Not because something startled her. Not because she forgot where she was going. She stopped because she noticed. In 35 years of legal practice and decades on that bench, Judge Judy has developed the specific perceptual acuity of someone who has learned that what a person does in the first 10 seconds of entering her courtroom tells her almost everything she needs to know about the next 30 minutes. And what Karen Belfield did in those first 10 seconds, or more precisely, what she refused to do, told Judge Judy something so clear and so complete that the folder in her hand became almost unnecessary. The courtroom went silent in the way that rooms only go silent when something has happened that no one has a script for. The bailiff's voice simply stopped, trailing off mid-syllable like a song whose record has been pulled from the turntable. The plaintiff, Linda Marsh, who was standing at the opposite table with her hands clasped in front of her, turned her head slowly toward Karen with an expression that was equal parts disbelief and the weary recognition of someone who was not entirely surprised. 3 women in the front row of the audience turned to look at each other with the wide, disbelieving eyes of people who want to confirm that someone else is seeing what they are seeing. A production assistant standing near the back wall lowered her clipboard. And the hum of the studio lights, those steady fluorescent fixtures that are always there and never noticed, became somehow the loudest thing in the entire room. Judge Judy did not rush. She never rushes. Rushing is for people who are not in control of what is happening, and Judge Judy has been in control of every room she has walked into for the better part of 4 decades. She stood at the edge of her bench, her black robe perfectly still, and she looked at Karen Belfield with the particular quality of attention that people in that courtroom have learned to recognize as the moment before everything changes. It was not angry attention, not yet. It was something more unsettling than anger. It was the focused, unhurried attention of someone who has just received a piece of information they already know exactly what to do with. What you are about to witness is not simply a courtroom argument. It is not simply a property dispute between 2 neighbors who stopped getting along. What happened in the next 60 seconds of this episode, 60 seconds that have since been replayed, shared, dissected, and discussed in ways that no one in that studio that morning could have anticipated, is something far more fundamental than a legal ruling? It is the story of what happens when someone walks into the one room in America where attitude has never once been an acceptable substitute for accountability, and discovers that the woman behind that bench has seen every version of this performance before and has never once been impressed by any of them. Karen Belfield came to this courtroom to win a case. She walked out having lost something she did not even know she was risking, the goodwill of every single person in that room, including an audience that arrived as strangers and left as unanimous witnesses to one of the most spectacular self-inflicted courtroom disasters in the history of this show. In 30 years of practicing law, Karen's own attorney would later say, he had never seen a client destroy their own case before the judge had taken her seat. He had never seen a room turn so fast, so completely, and so irreversibly. He had never, in 3 decades of watching people make bad decisions under pressure, seen anything as preventable, or as total, as what Karen Belfield chose to do in that moment. And all she had to do was stand up. Before we get into what happened next, drop your city in the comments right now, tell us where in the world you're watching this from, hit that subscribe button because this one gets so much worse before it gets better, and smash the like button if you believe respect costs absolutely nothing. To understand what happened in that courtroom, you have to understand who Karen Belfield was before she ever walked through those studio doors. You have to understand the specific architecture of a person who could sit in a room full of rising bodies, hear an official announcement, feel the collective movement of every human being around her, and choose, consciously, deliberately, with full awareness of what she was doing, to remain seated. Because that choice did not come from nowhere. That choice came from years. It came from a life lived in the particular way that Karen Belfield had lived hers. A life in which the rules that governed other people's behavior had always been experienced as optional suggestions that did not necessarily apply to someone with her level of discernment and her specific understanding of how things ought to work. Karen Belfield had grown up in the kind of household where complaining to management was considered a life skill. Her mother had been the woman at the restaurant who sent food back 3 times and left a note on the receipt instead of a tip. Her father had been the man at neighborhood association meetings who spoke longest, listened least, and confused the volume of his own voice with the validity of his opinions. Karen had absorbed both of these qualities with the thoroughness of someone who had been taught that the world was divided into 2 kinds of people, those who accepted what they were given, and those who demanded better. She had spent her entire adult life believing she was the second kind. What she had never stopped to examine was whether what she was demanding was actually better, or simply more. By her mid-30s, Karen had built a small but profitable portfolio of rental properties in the suburb where she lived, and she managed them with a combination of legal exactitude and interpersonal aggression that her tenants described, depending on how recently they had moved out, as either rigorous or punishing. She knew tenant law with the obsessive precision of someone who had spent years using knowledge as a weapon rather than a tool. She knew exactly how long she could delay a repair before it crossed into negligence. She knew exactly how to word a lease clause to maximize her leverage and minimize her liability. She knew how to make people feel that any complaint they raised was not only incorrect but was itself a kind of violation of the agreement they had entered into by choosing to rent from her in the first place. She had never lost a formal legal dispute, not because she was always right, but because the people she disagreed with had consistently lacked either the resources or the energy to fight her all the way to a resolution. This was perhaps the most important thing about Karen Belfield that her $4,200 lawsuit against Linda Marsh had failed to account for. She had spent so many years winning through attrition, through the sheer exhausting relentlessness of her pursuit of whatever she had decided she was owed, that she had never developed the ability to accurately assess a situation in which the other party was not going to simply give up. She had never had to reckon with a room that would not bend to her. She had never sat across from someone who was not eventually going to find it easier to concede than to continue. She had, in other words, spent decades becoming very skilled at a very specific kind of conflict, and she was about to discover that the courtroom she had walked into that morning operated by entirely different rules than the ones she had spent her life mastering. Her relationship with Linda Marsh had followed the standard Karen Belfield trajectory with depressing predictability. Linda had moved into the house next door 6 years earlier, a recently retired schoolteacher who had spent 3 decades managing classrooms full of 9-year-olds and arrived in her retirement with the patient, practical, fundamentally decent outlook of someone who had dedicated her professional life to the belief that most problems between people can be resolved with honesty and goodwill. She had introduced herself to Karen with a plate of homemade lemon bars the weekend she moved in. Karen had accepted the plate, commented that she hoped Linda was aware of the neighborhood rules regarding front yard landscaping, and gone back inside. This was, in retrospect, a reasonably accurate preview of the 6 years that followed. The specific dispute that had landed them both in front of Judge Judy had begun 14 months earlier when Linda hired a licensed contractor to replace the aging wooden fence that ran along the shared boundary line between their 2 properties. The fence had been there for over 20 years. It was rotting at the base, leaning at an angle that had become both an eyesore and a genuine structural concern, and Linda, after consulting with the contractor and reviewing the county property survey she had requested for exactly this purpose, had proceeded with the replacement. She had knocked on Karen's door 3 days before the work began to inform her of the timeline. Karen had not answered. Linda had left a written note. The note had not been acknowledged. On the 2nd day of construction, one of the workers accidentally knocked over a ceramic garden ornament that had been sitting near the base of the fence on Linda's side, a small painted bird that had belonged to Linda's mother and had been sitting in that garden for 11 years. The ornament cracked along the base. It was not destroyed. It was cracked. Linda was upset, genuinely, understandably upset, because the bird had sentimental value that had nothing to do with its monetary worth. When the contractor offered to replace it, Linda told him it could not be replaced because it had been her mother's, and the conversation ended there with Linda absorbing a small loss with the quiet grace of someone who understood that accidents happen and that the measure of a person is not whether bad things occur but how they respond when they do. Karen's response, when she learned of the incident, was to call a paralegal. The demand letter arrived at Linda's door 9 days later. It was 3 pages long. It itemized the boundary fence as a shared structure that had been replaced without Karen's written consent, a claim that conveniently ignored the note Linda had left and the property survey that placed the fence on shared land, and it attached a replacement estimate for an ornament that had never been Karen's property, had never been on Karen's side of the fence, and had not been destroyed but merely cracked. The total demand, after the paralegal's fees were added to the fictional damages, came to $4,200. The letter included a deadline of 30 days and a veiled reference to further legal action if the amount was not paid. Linda Marsh, who had spent 31 years teaching children that fairness mattered and that standing up for what was right was worth the difficulty it sometimes required, read the letter twice, sat down at her kitchen table, and called a legal aid organization. She was not going to pay $4,200 for a cracked ornament that was not Karen's and a fence dispute that the county survey had already answered. She was going to fight it. And that decision, the decision of a 68-year-old retired schoolteacher to refuse to be bullied out of $4,200 she did not owe, was the reason both of them were now standing, or in Karen's case conspicuously not standing, In the most famous small claims courtroom in the history of American television, Karen had arrived at the studio that morning with the energy of someone preparing for a formality. She had organized her folder the night before with color-coded tabs. She had selected her blazer after trying on 4 others. She had rehearsed her opening statement in the bathroom mirror with the focused repetition of someone who was not preparing to argue a case so much as to perform a victory she had already scripted in her head. She told the producer who walked her through the pre-show briefing that she had done her research, that she understood property law, and that she was confident the facts would speak for themselves. When that same producer explained, clearly and specifically, that when Judge Judy entered the courtroom everyone was required to stand, Karen had nodded with the distracted half-attention of someone filing information they have already decided is not relevant to them. She had been doing that her whole life, filing other people's instructions under irrelevant. It had worked for 44 years. It was about to stop working in the most public and permanent way imaginable. Because the room she was sitting in was not a rental property office where she controlled the lease terms. It was not a neighbor's doorstep where she could leave a certified letter and walk away. It was not a customer service counter where a manager could be summoned and a complaint could be filed and the path of least resistance would eventually bend in her direction. It was Judge Judy's courtroom. And in Judge Judy's courtroom, the path of least resistance runs in exactly one direction, toward honesty, toward humility, and toward the basic human decency of acknowledging that other people in the room exist and deserve to be treated as if they do. Karen Belfield had spent 44 years perfecting the art of not doing that. She was about to spend the next 60 minutes discovering what it costs. There is a specific quality of silence that only exists in rooms where something has gone profoundly, irreversibly wrong. It is not the silence of a pause. It is not the silence of people waiting for what comes next. It is the silence of people who have just witnessed something that has rewritten the rules of the room they are sitting in, and who are collectively holding their breath while their brains catch up to what their eyes have just seen. It is the silence of a classroom when a student has said something so out of bounds that the teacher has stopped mid-sentence. It is the silence of a dinner table when someone has said the thing that cannot be unsaid. It is a living silence, dense and directional, and every single person in that studio that morning felt it land on them like a physical weight the moment Judge Judy stopped walking and turned her full attention toward the one person in the room who had remained in her seat. That silence lasted 4 seconds. 4 seconds is not a long time in most contexts. In this context, it was an eternity. It was long enough for the camera operator on the left side of the studio to make a wordless professional decision and begin a slow zoom toward Karen Belfield's face. It was long enough for the bailiff, a man who had worked this courtroom long enough to have seen virtually everything, to register what was happening and make the calculation that this was not a situation that required his intervention but rather his absolute stillness. It was long enough for Linda Marsh, standing at the plaintiff's table with her hands clasped in front of her and her face arranged in the careful neutrality of someone who has learned to manage her reactions around Karen Belfield, to allow herself one brief, involuntary glance across the room at the woman who had sent her a 3-page legal demand over a cracked ceramic bird. And it was long enough for Karen herself to become aware, not fully, not with complete understanding of what was coming, but aware in the specific way that the body sometimes knows things before the mind is willing to accept them, that the temperature of the room had changed. Judge Judy set her folder down on the bench. She did not sit. This was the first signal, and anyone who has watched this courtroom long enough knows exactly what it means when Judge Judy sets her materials down and does not sit. Sitting means the proceedings are beginning, the case is being heard, the normal machinery of the courtroom is in motion. Not sitting means something else entirely. Not sitting means that before any of that can happen, something in this room needs to be addressed. Something has presented itself that takes priority over the schedule, over the case file, over the $4,200 dispute that both parties had driven here this morning to resolve. Not sitting means that Judge Judy has something to say that she wants everyone in this room to hear while she is still standing, because what she is about to say deserves the full physical weight of her presence behind it. She looked at Karen Belfield with the specific quality of attention that is the professional product of 35 years of sitting across from people who are lying, people who are hiding things, people who are performing emotions they do not feel and suppressing emotions they do not want seen. It was not a dramatic look. It was not theatrical or exaggerated. It was simply direct, the gaze of someone who has learned that the fastest path to the truth of any situation is to look at it without flinching and without the courtesy of pretending you have not seen what you have seen. And what Judge Judy had seen, in the 10 seconds since she walked through that chamber door, was a woman sitting in her courtroom with her arms folded and her chin lifted, making a choice that was communicating something far louder than anything Karen Belfield was going to say once the microphone was in front of her. When Judge Judy spoke, her voice was quiet. This is the thing that people who have never watched this courtroom do not understand. They expect volume, they expect the sharp theatrical delivery that has made her famous, and sometimes that is exactly what they get. But the moments that matter most in this courtroom, the moments that cut deepest and land hardest and stay with people long after the episode has ended, those moments almost always arrive in the quiet register. Because quiet, in a room that has just gone silent, carries further than any shout. Quiet says I do not need to raise my voice because what I am about to say is heavy enough on its own. She said, "Excuse me. Did you just choose not to stand when I entered this courtroom?" 10 words. The simplest possible construction. Subject, verb, object. No rhetorical flourish, no build-up, no preamble. Just the question, placed into the silence of the room like a stone dropped into still water, and then the spreading rings of it moving outward through every person present. The camera on Karen's face caught the precise moment the question arrived, the almost imperceptible tightening around her eyes, the microsecond recalibration of her expression as she processed what she had just been asked and began assembling her response. And here is where the story of Karen Belfield's 60 seconds truly begins, because the response she assembled, the answer she reached for in that moment, revealed more about who she was than anything else she did or said in the entire episode. A different person might have stood immediately, apologized, and moved on. A person with any functional awareness of the room they were sitting in might have recognized that the correct response to being called out by Judge Judy for not standing was to stand, to apologize genuinely, and to allow the episode to proceed in the way that everyone present preferred. A person with even a minimal instinct for self-preservation might have understood that the woman behind that bench had seen this exact energy thousands of times and that the only viable path forward was immediate, unconditional course correction. Karen Belfield was not that person. Karen Belfield turned her head toward Judge Judy with the slow, deliberate rotation of someone who is being interrupted from something more important, arranged her expression into something that sat exactly at the midpoint between polite and dismissive, and said, with a small shrug that the camera captured in its entirety, "I didn't think it was mandatory." The audience inhaled. Not loudly, not as a single theatrical gasp of the kind that gets edited into reality television for effect, but as the genuine, involuntary, collective intake of breath that a group of people produces when something happens that none of them expected and all of them immediately recognize as significant. It was the sound of 37 people simultaneously processing the information that this woman who had just been asked a direct question by Judge Judy in Judge Judy's own courtroom, had responded not with an apology, not with a correction, not with any acknowledgement that she had done something that warranted either, but with a shrug and a half-sentence that managed to be simultaneously defensive, dismissive, and almost incomprehensibly tone-deaf. Linda Marsh, at the plaintiff's table, closed her eyes for 1 second. It was a gesture so brief that most people in the room missed it, but the camera on the plaintiff's side caught it perfectly, that single, quiet second of a woman absorbing the confirmation that the person who had been making her life difficult for 6 years was, in this most public and consequential of settings, going to continue being exactly who she had always been. Judge Judy did not move. She did not reach for her folder. She did not shift her weight or adjust her glasses or make any of the small preparatory gestures that signal a transition from one moment to the next. She simply continued looking at Karen Belfield with the patient, unhurried attention of someone who has just received the answer they were expecting and is now deciding exactly what to do with it. When she spoke again, her voice had not risen in volume, but something in its quality had changed, a density had entered it, a weight that made each word feel individually placed, individually chosen, like stones being laid one at a time along a path that was going to lead somewhere Karen was not going to enjoy. "Let me explain something to you," Judge Judy said. "Standing when a judge enters a courtroom is not a suggestion. It is not a preference. It is not a tradition that some people observe and others feel free to skip based on their own assessment of whether it applies to them. It is the most basic acknowledgement of respect for a process that exists to protect every person in this room, including you. When you choose not to stand, you are not making a statement about your independence. You are making a statement about your character. And the statement you just made told me more about this case than anything in that folder in front of you." 15 seconds. That was how long it took. 15 seconds of quiet, precise, devastatingly accurate language, and the room had already moved. Not dramatically, not all at once, but in the way that crowds move when a collective understanding settles over them, one person at a time reaching the same conclusion and the conclusion spreading, person to person, until the entire room is oriented in the same direction. The three women in the front row who had exchanged glances when Karen stayed seated were no longer exchanging glances. They were looking at Karen with the focused, unanimous attention of people who have made up their minds. A man in the fourth row shook his head, a small, involuntary motion, the physical language of someone who cannot quite believe what they are watching. A woman near the aisle leaned forward with her elbows on her knees, her body language the body language of someone who is no longer casually watching television but is personally invested in what happens next. And Karen, sitting at the center of all of this, with the studio lights above her and the cameras on her and 37 audience members and one of the most formidable judicial minds in American television history all focused entirely on her. Karen sat with her arms still folded, and the chin came down perhaps 2 degrees from where it had been, and something moved behind her eyes that was not quite recognition but was the beginning of it. The faintest leading edge of the understanding that was going to arrive in full, devastating clarity over the next 25 minutes. The understanding that she was not in a rental property dispute. She was not in a conversation she could end by sending a certified letter. She was not in a room that was going to eventually find it easier to accommodate her than to confront her. She was in Judge Judy's courtroom. And Judge Judy had not even opened the case file yet. There is a particular kind of confidence that exists only in people who have never been genuinely tested. It is different from the confidence of someone who has faced difficulty and come through it. That kind of confidence has texture to it, has been worn smooth by contact with reality, has the quality of something that has been pressure tested and held. The confidence Karen Belfield carried into that courtroom was the other kind. It was the bright, brittle confidence of someone who had spent years winning arguments against people who were not equipped to fight back, and had confused that winning streak with actual competence. It was the confidence of someone who had rehearsed her lines without ever seriously considering that the other side might have lines of their own. And as Judge Judy finally settled into her chair, opened the case file, and began the methodical process of examining exactly what Karen Belfield was claiming and exactly what evidence she had brought to support those claims, that confidence began to develop the specific hairline fractures that precede a complete structural collapse. Judge Judy opened with the numbers, because Judge Judy always opens with the numbers. In 35 years of legal practice, she has learned that the fastest way to understand what a case is actually about, as opposed to what the person filing it claims it is about, is to look at what is being demanded, in what amounts, and with what justification. The total demand was $4,200. Judge Judy read each line item aloud with the deliberate pace of someone who wants every person in the room to hear exactly what is being claimed and have the opportunity to assess it for themselves. $1,500 for the fence replacement, representing Karen's claimed share of a boundary structure she asserted had been replaced without her consent. $800 for the ceramic garden ornament that had been cracked during construction. $1,200 in what the demand letter described as costs associated with property disruption and inconvenience during the construction period, and $700 in emotional distress damages, a line item that Judge Judy read twice, not because she had not heard it correctly the first time, but because she wanted the courtroom to hear it twice. She looked up from the folder. "You're claiming $700 in emotional distress," she said to Karen, her voice carrying the particular flatness of someone removing all editorial inflection from a sentence because the sentence is sufficiently extraordinary on its own. "Because your neighbor replaced a fence." Karen straightened in her chair with the posture of someone who has been waiting for the opportunity to explain themselves and believes that explanation is going to resolve everything. "Your Honor, it wasn't just about the fence. The entire process was disruptive and stressful, and I believe I'm entitled to be compensated for the impact that Mrs. Marsh's unilateral decision had on my daily life and my—" "Stop," Judge Judy said. Not unkindly, but with the absolute finality of a door being closed. Emotional distress in a legal context has a specific meaning. It requires a specific threshold. Being inconvenienced by construction next door does not meet that threshold. Being stressed because your neighbor made a decision you didn't like does not meet that threshold. Mrs. Belfield, emotional distress is not a line item you add to a demand letter because you were annoyed. Courts have standards for this. Your paralegal apparently does not. The reference to the paralegal landed visibly. Karen's jaw tightened, a small, involuntary muscular response that the camera on her side of the room caught with the patient thoroughness that good camera operators bring to moments they recognize as significant. It was the first physical evidence of something cracking beneath the surface of Karen's performance, and it was produced not by an attack on Karen herself but by a precise, accurate observation about the quality of the legal help she had paid for. This was a technique that anyone who has watched Judge Judy for more than 3 episodes will recognize. She rarely goes for the emotional jugular first. She goes for the structural foundations. She examines the scaffolding of the argument, identifies where it is weakest, and applies pressure there, because she understands that a person can defend themselves emotionally for a long time, but they cannot defend a bad argument once its central supports have been removed. She turned to the fence claim next, and this was where the folder that Linda Marsh's legal aid attorney had prepared began to do its quiet, devastating work. Judge Judy held up the county property survey, a document that had been filed as evidence before either party set foot in the studio and that Judge Judy had clearly reviewed in the preparation that she brings to every case she hears. The survey was not ambiguous. Property surveys, by their nature, are not in the business of ambiguity. They deal in measurements, in boundary lines, in the specific and recorded facts of where one person's land ends and another person's begins. And what this particular survey showed, in the clear and unromantic language of official documentation, was that the fence line in question sat squarely on the shared boundary between the two properties, which meant it was, legally and factually, a shared structure, which meant that neither party had the unilateral right to dictate its replacement terms, and which meant that the premise of Karen's $1,500 claim was not merely overstated but was built on a foundation that did not exist. Judge Judy placed the survey on the bench in front of her and looked at Karen with an expression that contained no cruelty and no theatrical satisfaction, just the straightforward attention of someone presenting a fact and waiting for the other person to account for it. "Mrs. Belfield, according to this survey, which is the official county record of the property boundary between these two homes, the fence sits on the shared line. Not on your property. The shared line. Which means Mrs. Marsh had as much right to replace it as you did. Do you understand what that means for your claim that she acted without your consent?" Karen opened her mouth. She closed it. She opened it again. What came out was not the confident, rehearsed response of someone who had prepared for this question, because Karen had not prepared for this question. She had not prepared for this question because she had never seriously entertained the possibility that the survey would say what it said, or rather, and this is the more precise and more damning truth, she had not consulted the survey before filing her claim. She had operated, as she had always operated, on the basis of what she believed to be true rather than what the available evidence confirmed. I was under the impression, she said carefully, that the fence was on my side of the line. Your impression, Judge Judy replied, is not a legal standard. The survey is a legal standard. And the survey says you were wrong. She set the document down with the quiet finality of someone placing a period at the end of a sentence. Next. The ornament claim came third, and it came with Linda Marsh's testimony, and Linda Marsh's testimony was the kind of testimony that courtrooms are built to receive and that lawyers spend years trying to teach their clients to deliver: quiet, specific, honest, and entirely without performance. Linda spoke in the measured cadence of a woman who had spent 3 decades explaining things clearly to people who needed to understand them, and she explained what had happened to the ceramic bird with the straightforward accuracy of someone who was simply telling the truth and trusted that the truth was sufficient. She described the ornament. She described where it had sat in her garden for 11 years. She described her mother, briefly and without melodrama, simply establishing why the object mattered in a way that had nothing to do with its replacement value. She described the contractor knocking it over, the crack along the base, the offer to replace it that she had declined because the thing that made the ornament valuable was the thing that could not be replaced. And then she said the thing that reoriented the entire room's understanding of the dispute they were witnessing. I never asked Karen for anything, Linda said quietly. I didn't ask her to pay for the fence. I didn't ask her to compensate me for the ornament. I didn't ask her for anything at all. I knocked on her door before the work started and she didn't answer. I left a note and she didn't respond. And then 9 days after the construction was finished, I received a letter from a paralegal telling me I owed her $4,200. The room absorbed this. It absorbed it the way rooms absorb information that reframes everything that came before it, not with noise, not with immediate reaction, but with a settling quality, a recalibration, a collective adjustment of the mental image that everyone present had been building of these 2 women and the dispute between them. Because what Linda had just described was not a property dispute in the conventional sense, 2 parties with competing legitimate claims, each with their own reasonable interpretation of events, coming to a neutral authority to have the disagreement resolved. What she had described was something else entirely. She had described a woman who had not been harmed going after a woman who had done nothing wrong, with a demand that bore no relationship to any actual damage, filed through a paralegal rather than an attorney because no licensed attorney had looked at the facts and concluded this was a viable claim. Judge Judy let the silence after Linda's testimony exist for a moment longer than strictly necessary. She was, in her way, giving it room to work on the people in that room, giving the audience, giving Karen, giving the cameras the space to fully receive what had just been said before she added anything to it. Then she turned to Karen and asked the question that completed the demolition of everything Karen had built her case on. Mrs. Belfield, she said, looking at what Mrs. Marsh has just described, looking at the survey, looking at the demand letter, looking at the fact that this woman knocked on your door and left you a note and received no response and then 9 days after the work was finished got a bill for $4,200, I want to ask you something directly. Is this case about a fence and a garden ornament? Or is this case about something else? Karen said, I don't know what you mean. Judge Judy said, I think you do. And in the front row of the audience, the woman who had leaned forward with her elbows on her knees, who had been sitting in that position since the 60-second confrontation at the beginning of the episode, slowly shook her head. Not with anger. Not with the performed disgust of someone playing to a camera. With the specific, tired, deeply human headshake of someone who has watched this before, in other rooms, with other names attached to it, and who recognizes it for exactly what it is. A bully in a blazer with a color-coded folder, sitting across from a decent woman who made the mistake of refusing to simply pay what she was told to pay. And a judge who had seen it so many times that she could name it before the first witness had finished speaking. CTA number 2, middle of script. If Judge Judy is handling this exactly the way you hoped she would, hit that like button right now, subscribe so you catch every moment we post, and drop your city in the comments. We want to know where in the world justice has fans today. Karen's final mistake was fighting back. As Judge Judy began her summary, Karen interrupted, rolled her eyes on camera, and muttered under her breath loud enough for the microphones to catch every syllable. Judge Judy stopped mid-sentence and looked at her with the stillness of someone who has just run out of patience for a performance they have seen too many times to find interesting anymore. Mrs. Belfield, you have interrupted me twice, rolled your eyes at this bench, and have yet to present a single piece of evidence that survives basic scrutiny. What you have presented instead is a pattern, and that pattern tells me everything this case is actually about. The audience erupted. Sustained, spontaneous applause that the bailiff made no real effort to stop because even he understood that what the room was feeling was not entertainment but justice. Linda Marsh sat with her hands folded and her eyes glistening, the quiet vindication of a decent woman who had refused to be bullied settling over her like something long overdue. Judge Judy's ruling was total and swift. Karen's claim was dismissed entirely. Linda was awarded full court costs. The emotional distress demand was rejected with a single line that the internet would quote for years afterward: emotional distress requires more than the experience of not always getting your way. Karen gathered her color-coded folder with hands that were no longer steady and walked out of that courtroom without looking at Linda, without looking at the audience, and without looking at the bench where a woman had just seen through every layer of her performance and named what was underneath it with surgical and permanent accuracy. Linda paused at the door on her way out, looked back at the courtroom once, nodded to herself quietly, and left. The clip spread within hours. Millions watched Karen refuse to stand. Millions watched the room turn. And millions understood, in the way that only the clearest moments of public accountability allow us to understand, that respect is never about the person you are giving it to. It is always, entirely, about the person you are. If this story reminded you that respect is always a choice, like this video right now, subscribe so you never miss a moment of real justice being served, and drop your city in the comments below. We read every single one and we want to know where our community is watching from today.